My name is Marian Honnell. I'm the manager of Fair Housing at the Illinois Department of Human Rights. On behalf of our director, Rocco Kleps, let me welcome you to our webinar on the rights of lesbian, gay, bisexual, and transgender persons and fair housing. This presentation is intended for LGBT persons who want to learn about their fair housing rights, as well as for housing providers, including landlords and property managers, who want to learn about how not to discriminate against people who are gay, lesbian, bisexual, or transgender. The information contained in this webinar is for educational and informational purposes only and is not intended to be considered legal advice. During this presentation, we will cover some definitions, explain what fair housing is, give examples of housing discrimination against LGBT persons, tell how a charge is filed and investigated at the Illinois Department of Human Rights, and conclude with some recommendations. First, for anyone who may not be familiar with the terms, we are going to define sexual orientation, gender identity, and LGBT. Under the Illinois Human Rights Act, sexual orientation is defined as actual or perceived heterosexuality, homosexuality, or bisexuality. Sexual orientation is about who a person is attracted to, whether someone of the opposite sex, heterosexual, or someone of the same sex, homosexual. Male homosexual people are commonly referred to as gay and females as lesbian. Bisexual people are those for whom gender is not the first criteria in determining attraction. Under the Human Rights Act, a protected class of sexual orientation also includes gender identity, which the Act defines as gender-related identity, whether or not traditionally associated with the person's designated sex at birth. Another definition of gender identity is a person's sense or experience of belonging to a particular gender category as a man or a woman, and where a person feels they fit in society's man-woman structure. The term LGBT refers to lesbian, gay, bisexual, and transgender persons. Lesbian, gay, and bisexual refer to types of sexual orientation. Transgender is an umbrella term for people whose gender identity or expression does not match the cultural norm for their biological sex. This umbrella term includes identities such as transsexual, genderqueer, and cross-dresser. Transgender persons may identify as male or female, as both or neither. Persons from all races, religions, national origins, and abilities may identify as LGBT. Sometimes Q is added onto the LGBT acronym and stands for queer or questioning. Questioning may occur during a developmental stage when young people may struggle with issues of sexuality, gender, and identity. This struggle can be especially difficult and prolonged for people exploring LGBT sexual orientations and gender identities. Some people prefer to refer to themselves as queer rather than gay or lesbian. So let's define what we mean by fair housing. Fair housing is all about choice. Under federal and state fair housing laws, everyone has the right to seek, purchase, sell, lease, or rent a home without unlawful discrimination, interference, coercion, threats, or intimidation by owners, landlords, real estate agents, or any other persons. An individual's ability to obtain housing significantly impacts all aspects of their daily life. A person's housing choice is often based on cost, safety, amenities and condition of the home, or proximity to work, schools, stores, and transportation. The U.S. Department of Housing and Urban Development, or HUD, estimates that more than 2 million instances of housing discrimination occur each year, but fewer than 1% are reported. Housing discrimination is not always manifested in a negative way. Discrimination can be subtle, and home seekers may be treated in a polite manner, even while they are being discriminated against. If a home seeker is denied housing of their choice, despite being qualified to live there, that may be an instance of housing discrimination. Several laws have been enacted in order to protect people from discrimination. One of the very early laws that banned discrimination in the use, purchase, lease, or transfer, etc. of real estate and property was the Civil Rights Act of 1866. This law was rarely used. Title VIII of the Civil Rights Act of 1968, also known as the Fair Housing Act, was passed by Congress 4 days after the assassination of Martin Luther King Jr., who was an advocate for equal and open housing. At that time, the Fair Housing Act covered only 4 protected classes: race, color, religion, and national origin. Sex was added as a protected class in 1974. In 1988, the law was renamed the Fair Housing and Amendments Act, and disability and familial status were added as protected classes. And also, an administrative enforcement mechanism was put in place so that people didn't have to go to court but could file complaints at a local HUD office or substantially equivalent state or local agency. So let's define some of the protected classes. Race is a social construct which refers to physical attributes associated with certain geographical regions and often certain cultural characteristics or stereotypes. Race generally refers to white, black, or African American, Asian, and American Indian. Hispanic and Latino are considered ancestry, not race. Color refers to people with different skin tones, even within the same racial group. National origin refers to the country in which a person was born or the country of a person's ancestors. Sex refers to male or female, and under this category, sexual harassment is also unlawful. Disability refers to physical or mental disabilities, as well as perception of a disability and history of a disability. There are different definitions of disability under the state and federal fair housing laws, but in general, disability refers to a serious medical condition or functional impairment that is not temporary. Familial status refers to the presence of children under 18 in the home. Pregnant women and persons seeking legal custody of children are also included in this category. The Illinois Human Rights Act, which was effective in July 1980, created the broadest civil rights coverage for the people in Illinois in the history of the state. It is equivalent to the federal law and includes additional protections. Age refers to persons 40 and over. Ancestry refers to the region where a person or his or her ancestors are from, such as Middle East or Eastern Europe. Marital status means the legal status of being married, single, divorced, separated, or widowed. Unfavorable military discharge offers protection to persons whose discharge was less than honorable but not dishonorable. Military status refers to service members on active duty, as well as veterans and members of the reserves. Willful interference and coercion protects people from actions by neighbors or others not engaged in a real estate transaction. However, there usually needs to be violence or threats of violence in order to overcome a person's First Amendment right of free speech and rise to the level of discriminatory interference with a neighbor's housing enjoyment. Sexual orientation and gender identity was effective in 2006, and we've already defined that. The last one is order of protection status, which was effective in 2010. Order of protection status is defined as a person protected under an order of protection issued pursuant to the Illinois Domestic Violence Act of 1986 or an order of protection issued by a court of another state. So these are the protected classes covered by the state fair housing law, in addition to the ones also covered by the federal fair housing law. And in Chicago, Cook County, and some other jurisdictions with local fair housing ordinances, there are additional protected classes that are covered under those ordinances. For example, the City of Chicago protects source of income, and that includes housing choice voucher holders. Cook County also protects source of income, but its definition excludes housing choice voucher holders. All of the following actions are unlawful under the Human Rights Act and Federal Fair Housing Amendments Act if the reason the action is taken is because of a person's protected class or association with a person in a different protected class. So refusal to rent or sell property includes refusal to engage in a real estate transaction, attempts to discourage someone from renting or buying housing, failing to discuss amenities in order to discourage someone from renting or buying, or otherwise making property unavailable, which could include, for example, not returning phone calls because of the accent of a person seeking the housing. Discrimination in advertising covers people or entities placing ads, advertising agencies preparing ads, and publishers that print ads, including newspapers, directories, and multiple listing services. All of these can be held liable for violating the law. Discriminatory statements also extends to discriminatory verbal statements that advertise an intent to discriminate in rental or sale of housing. However, courts have found that internet sites that act strictly as bulletin boards, where ads are posted by others, such as Craigslist, are not liable for discriminatory ads posted on the sites. The actual persons posting such ads, however, would be liable under the fair housing laws. Lying about or misrepresenting availability of a unit can be a fair housing violation, again, if the reason the property manager is lying is because they don't want to rent to someone because of their protected class. In the case of sexual orientation, even the perception of being gay, lesbian, bisexual, or transgender is covered as a protected class. So if a person finds an ad, goes to look at the housing, and then based on your appearance as transgender or gay or lesbian or whatever it is, if the landlord or property manager then says, oh, it's already been rented, it's no longer available. And if you suspect that they're lying because they believe you're a member of a particular protected class, even if you're not in that protected class and they just perceive you to be in that protected class, you could file a charge alleging discrimination. Another illegal act is altering the terms and conditions of a lease agreement. Examples of this are charging more for a security deposit because of someone's protected class, not allowing someone to use the same amenities as the rest of the tenants, maybe keeping you out of the pool because they think you're HIV positive. That might be disability discrimination. Or refusing to provide equal services such as maintenance or repairs to a unit. So anything that alters the terms and conditions of a lease would be covered under that provision. Blockbusting is a tactic to persuade owners to sell a rent by telling them that unwanted groups are moving into the neighborhood. And steering is a tactic used to discourage a buyer from living in a certain area and suggesting they seek housing in an area more appropriate to their group or where other members of their group live. So, for example, if a gay couple applied for housing and the property manager suggested that they should rent in the area of Chicago known as Boys Town because they would be more comfortable over there, well, that would be an example of steering based on sexual orientation. And that would be a violation of the fair housing laws because it's up to the person to decide where they want to live. It's all about choice. And finally, giving someone a different term or condition for receiving a loan could mean things like charging higher interest rates, charging more fees, or referring people to certain loan products because of the protected class. Illegal eviction procedures are a common problem for tenants, although not necessarily a fair housing violation. Some additional illegal acts covered by the fair housing laws include retaliation against someone who filed a charge or otherwise complained about discrimination, creating a hostile environment because of a protected class, for example, severely harassing someone because of their status as being gay, lesbian, or transgender, sexually harassing a tenant or buyer, that would also be a violation. And finally, it's important to note that people with disabilities are entitled to reasonable accommodations and modifications, which would allow them equal enjoyment of the housing. Failing to provide reasonable accommodations or to allow reasonable modifications is a violation of the fair housing laws. For more information on this topic, see IDHR's webinar on fair housing and persons with disabilities and the HUD Department of Justice guidance on reasonable accommodations and modifications. Discrimination can occur anywhere. Most types of properties are covered under the law, even some you might not expect, including co-ops and condos, worker housing, migrant farm worker housing, summer homes and timeshares, nursing homes, mobile homes, and even vacant lots if purchased for residential housing or commercial purposes. In Illinois, even real estate transactions involving commercial properties are covered under the fair housing laws. There are other places where people stay too. Hotels, campgrounds, and homeless shelters, for example, may sometimes be considered dwellings, and if so, they may be covered under the fair housing laws. Even when not considered a dwelling, people who use these accommodations may be protected from discrimination under the Illinois Department of Human Rights law banning discrimination in public accommodations. So while most properties are covered, there are some exemptions. The owner-occupied exemption, sometimes called the Mrs. Murphy exemption, provides that if an owner lives in a building that has 4 or fewer units, in other words, they're living in one unit and renting out the other units in the building, that building is then exempt from coverage under federal and state fair housing laws. However, there's no exemption if a landlord makes discriminatory statements. And also, a local ordinance may still cover the building. For example, Cook County and the City of Chicago do not have an exemption for small owner-occupied buildings. And there's no exemption for race discrimination. That's always covered by that 1866 law. There are several other limited exemptions that cover only 1 or 2 protected classes. In other words, they give an exemption only for 1 or 2 protected classes. Nonprofit religious organizations, for example, that administer residential housing, such as nursing homes or retirement communities, are allowed to give a preference to persons of their same religion. But they can't discriminate against anyone on any of the other protected classes. They only have the exemption to discriminate based on religion. And there's some affordable housing that may legally be set aside for people with specific types of disabilities. And then finally, there's an exemption for senior buildings. So buildings reserved for seniors are allowed to discriminate based on age and familial status. They are allowed to keep families with children out of the building as long as they're following the rules for senior buildings. Although sexual orientation and gender identity are not yet recognized as protected classes under federal fair housing law, the U.S. Department of Housing and Urban Development, or HUD, issued a rule in 2012 prohibiting discrimination based on sexual orientation and gender identity in housing that's federally funded. Among the aims of the rule is a prohibition on inquiries regarding sexual orientation or gender identity, as well as a prohibition on using sexual orientation or gender identity as grounds for decision-making in Federal Housing Administration or FHA programs. Additionally, the rule clarifies that eligible families for using that housing includes those who are lesbian, gay, bisexual, and transgender. HUD recently settled a case with the Bank of America based on sexual orientation and marital status that involved an FHA loan that HUD says was denied because the applicants, a lesbian couple, were not married. To settle this case, Bank of America paid $7,500 and made changes to its policies and training practices. This is the first lending case that HUD settled involving its new executive order, barring discrimination based on sexual orientation, gender identity, and marital status in HUD programs. Also, HUD has indicated that it will now accept transgender cases filed under the protected class of sex if the reason for discrimination is alleged to be the person's nonconformity with gender stereotypes. HUD's issuance and enforcement of this rule and its broader interpretation of the sex category to include transgender status is significant because HUD issues guidance and sets policy on fair housing issues nationwide. This rule also moves the federal government in the direction of broader federal protection overall based on sexual orientation and gender identity. A 2011 survey of 6,450 transgender individuals was conducted by the National Gay and Lesbian Task Force and the National Center for Transgender Equality. Their report, Injustice at Every Turn, found that 19% of respondents reported being refused a home or apartment because of gender identity, and 11% reported eviction because of gender identity. 19% of the transgender respondents also reported experiencing homelessness at some point in their lives, and when trying to access homeless shelters, over half reported outright denials, harassment, or sexual assault in the shelter context. Another study by Michigan's Fair Housing Center in 2007 found that 30% of same-sex couples were treated more negatively than opposite-sex couples when attempting to buy or rent the same property. The differing treatment ranged from outright refusing to sell or rent to a same-sex couple, showing the same-sex couple less desirable properties, quoting higher rent prices, and providing less favorable customer service. Gay individuals also reported verbal harassment from landlords, realtors, and lenders. HUD has launched a media campaign called Live Free to publicize its new rule, which strives to ensure that people have equal access to housing regardless of sexual orientation and gender identity. The Illinois Human Rights Act prohibits discrimination based on sexual orientation and gender identity. Since 2006, complainants have filed nearly 900 charges with the Department of Human Rights alleging discrimination based on sexual orientation. On average, about 3.5% of all charges filed at IDHR allege discrimination based on sexual orientation or gender identity. Now, the vast majority of these cases involved allegations of discrimination in employment. So, because we cover employment, housing, and public accommodations, I want to give you some examples of what those types of cases look like, just for background. So, an example of an employment case is a complainant who filed a charge alleging that his employer subjected him to harassment, unequal terms and conditions, and discipline because of his race, black, and because he was gay. So based on a settlement negotiated by our investigator, the complainant received $10,000 and a neutral reference. So that's an employment example. About 4% of our housing charges allege discrimination based on sexual orientation or gender identity. An example of a housing case is a case that alleges that a building owner contacted a realtor to find a tenant who would perform minor building maintenance in return for reduced rent. The realtor located a gay couple, but upon meeting them, the owner refused to rent to them, saying she couldn't rent a one-bedroom to two men. Even after the realtor told the owner her actions were illegal, she still allegedly refused to rent to the couple. So this case is still pending. And then in the area of public accommodations, about 10% of those cases have alleged discrimination based on sexual orientation or gender identity. An example of a public accommodations case is a case we have where the complainants allege that a bed and breakfast facility refused to host a reception to celebrate a gay couple's civil union due to their sexual orientation. So filing a charge is a great way to empower yourself if you believe that you may have been discriminated against. And if housing discrimination isn't reported, then it's hard to investigate. We can only investigate if someone reports a violation or an alleged violation. And it's important to know that a person who reports discrimination or files a charge is protected from intimidation or harassment, which would be considered retaliation if they report housing discrimination or any other kind of discrimination. So I want to go over the process for filing a charge. In order to file a complaint, which we call a charge of discrimination, with the Illinois Department of Human Rights, a person can start the process by calling IDHR and describing their situation. Our housing inquiry phone number is 312-814-6229, and that number is answered by a bilingual person who speaks English and Spanish. We can also be contacted via email at idhr.fairhousing@illinois.gov. Or a prospective complainant can complete our intake form online. After we get the information and review it, we will draft a charge if appropriate and send it to the complainant for signature. At the same time, we send the charge to the person or organization being charged with the act of discrimination, who's called the respondent. Once the respondent receives the signed charge, they have a duty to provide a written response. An investigator assigned to the case will ask both parties to consider a voluntary resolution to the matter. If the charge cannot be resolved or settled, the investigator requests information from all parties and will interview the complainant, the respondent, and any witnesses, and sometimes make a visit to the property. IDHR then makes a recommended finding and sends a report detailing the investigation conducted, in other words, the interviews conducted, the documents obtained, and explaining how our determination was made. Besides interviewing the complainant and the respondent and witnesses, the investigator collects documents and uses other evidence to determine whether there is substantial evidence of discrimination. To obtain testing evidence, a fair housing or disability organization typically sends out testers with similar profiles and housing needs, but with different protected class statuses, such as race, disability, or LGBT status, to the same available housing unit to see if they are treated differently because of their protected class. Without testing, housing discrimination may not be detected. So it's also important to note that the department cannot assess the credibility of anyone's testimony. In simple terms, this means that if the complainant and respondent have conflicting stories about what happened, the investigator doesn't decide who is telling the truth. But it doesn't mean that one party automatically wins if the parties disagree as to what happened. Most times there is other evidence in the case, so the decision does not rest on whether one or another of the parties is telling the truth or has believable evidence. However, if the resolution of the case requires believing the evidence of one party over another party, the department will make a finding of substantial evidence and refer the matter to the Illinois Human Rights Commission so that a judge may make a determination at a public hearing. If a judge finds that discrimination did occur, various types of damages can be awarded. Make-whole damages compensate the person for the damages caused by the discriminatory acts, such as actual or out-of-pocket expenses. These might include compensation for travel and time off work seeking other apartments, storage fees if applicable, and higher rent or travel expenses that may be incurred as a result of renting at another location instead of the preferred location. Compensatory damages also include damages for emotional distress, if that can be proved. The category of affirmative or injunctive relief can include things like reporting requirements, where apartment buildings have to keep a record of everyone who applies for the apartments and who gets in, monitoring for compliance, units set aside and free rent, required fair housing training, advertising and media targeted to the protected class involved in the case, and whatever else would undo the damage caused by the discrimination. A judge can also award civil penalties of up to $10,000 for the first offense, $25,000 for the second, and $50,000 for the third. And attorney's fees and costs can be a substantial portion of the damages. A person can file within 1 year after the alleged discriminatory practice occurs. In cases of ongoing, continuing discrimination, a complaint can be filed within 1 year after the practice ceases. A case can be filed up to 2 years after it occurs or ceases in state or federal court. And any time that the case was open at an administrative agency, such as IDHR or HUD, is told, meaning it is not included in calculating the 2-year filing period. In a case alleging housing discrimination based on sexual orientation or gender identity, we suggest filing with the Illinois Department of Human Rights, since sexual orientation is a protected class under state law, but not yet under federal law. If you are not sure if the federal fair housing law covers your case, you can always go to HUD, and if they don't think they have jurisdiction, they would probably refer the case to IDHR if they think that we would have jurisdiction. Also, HUD recently developed a fair housing app for the iPhone. Just enter the word discrimination in your app search function. It should come up and you can download it for free. The app has information about fair housing, and a charge can be filed with HUD right from the phone. Congratulations! You have taken steps to stop housing discrimination by learning about the fair housing laws. Hopefully this presentation has given you a basic understanding of the housing rights of people who are lesbian, gay, bisexual, or transgender. However, a general overview can't address every specific situation. For questions about how the fair housing laws apply to specific cases, you may wish to consult an attorney. If you suspect you may have been discriminated against, feel free to contact our office either by email, phone, or in writing, and we will let you know if your situation is something that we can investigate. If you are interested in learning more about fair housing, you may wish to review DHR's other webinars on other fair housing topics. For more information, see the resources handout associated with this webinar. Thank you very much.